The most common issues that are discussed in the cases these days, or among the most common, have to do with the scope of the executive power, obviously the Second Amendment and gun control. Fourth Amendment remains a lively area, in addition to due process and equal protection. The actual appointments have a great effect on the court, and you know, we see many 5-4 decisions in the last several years, and so any one appointment can turn some very significant cases. Go back a few years to World War II era and the case involving the internment of Japanese, the Korematsu case. Obviously that had a lot to do with the times. You know, the recent ruling on the Second Amendment, would that have been different 10 years ago or 20 years ago? I don't know. Or might it have been different 30 years from now? So I think the times are very significant, not just because of the differences in the justices, because, you know, one theory is that the court cannot stray too far from what's acceptable in society. There's a narrow range in which it can operate, and you get differences within that range. But if the court goes too far out of step with where society is, then you can run into questions about, you know, the legitimacy of the court. How does the court enforce its judgments if society is very unwilling to accept them? And sort of remarkably, we've avoided the constitutional crises you could have if the public just said to the heck with it, we're not going to follow that decision of the court. The prediction is that the next 2 or 3 openings will be among the 4 justices in the so-called liberal wing of the court. And so if Obama gets 2 or 3 appointments from that group, it won't make any difference, or very little difference. On the other hand, if any one of the 5 justices who are on the more conservative block of the court were to leave the court during Obama's time in office, then it could have a very significant effect. There was a time where we made a lot of progress in advancing civil rights. I think beginning with Brown versus the board, continuing maybe into the early 1970s. I think since then there's been a leveling off, if not a decline in terms of the scope of the rights. There's been some progress made since then in legislation. On the other hand, much of the litigation has not, much of the legislation has not filled its promise because of narrow interpretations. And so I think it's a checkered history. Well, number one, I disagree with it. But beyond that, the case actually decided very, very little. It does establish and it opens the door to extensive litigation based on the Second Amendment, because the court finds that there is a right there beyond the militia-related possession and use of arms. Or to put it another way, there's according to the court, a right there that speaks to, let's say, a self-defense related use of arms. So that's going to open the door to a lot of litigation, but the court actually decided very little because it's really skirted the whole issue of which of all those regulations out there will actually be found constitutional. And more importantly, how is the court going to evaluate the constitutionality of those? Another issue that was not addressed is whether the Second Amendment applies to state and local government. Even the majority of the court, in an opinion written by Justice Scalia, agree that the Second Amendment, like most constitutional provisions, is not absolute. Since the right that was found is not absolute, that means government can regulate guns. And the question becomes, to what extent may government regulate guns? There are already many cases filed, and there will be many more. Some would say the case is very good for lawyers because it will spawn much litigation.